For those who made depositions, they brought themselves before God with their depositions. We've granted you leave to cross-examine them on their deposition. The moment you proceed outside, I'll ask you to sit down, release the witness, and call the next witness.
Most obliged, we shall abide by that.
Thank you.
Yes, please. Just a small clarification.
Begin with your name.
Ladislas Rakafuza.
Thank you.
Now, my Lord, for example, we pleaded in our petition,
yes.
That is petition number 5, that the 29 million shillings that was given out to members of parliament for so-called consultations had not been budgeted for. That was in our pleadings.
Yes.
Now, Chris Mahakanezi, in his document showing the financial implications of the act as was passed, is silent on the 29 million shillings. Now, if he is silent on that, and yet we pleaded it, does that
But see, what does the law say if you plead something, somebody does not respond? What does the law say?
You see, what I've learned now, which is very disappointing, is that most of the time the court is giving legal aid to counsel. We are seeking clarification. We want you to help us on this matter. This is your case. You know how to deal with it.
Yes, my Lord, my concern is there are concealments. You may have made an affidavit, but concealed some pertinent facts. So when we are so restrictive on what they deponent, you may find that we may be closing out concealments, because most of them conceal what would be on the table.
Concealments are sort of by discoveries.
I don't mean in documents, in what they deponent.
No, you ask on the basis of what is stated in the affidavit. You can put to him something, but it must be based on what is said in the affidavit.
How can you know what a person has concealed in his head?
Yes, my Lord, you can know, because these things were in
Why don't we leave those matters to the actual cross-examination? When somebody raises a point that you think is not in the affidavit, they will object. Let's move on to serious business.
Yes, Learned Attorney General. I believe you're almost now handing over the matter to the lead counsel of the other side. Almost.
My Lord, mine is a question.
Your name?
My name is...
The guy that is telling me doesn't know you.
Most obliged, my Lord. Mine is for guidance, my Lord.
Yes.
The procedure that we are adopting is not very common in court, and with my few years of experience at the bar, I have not seen this kind of procedure before.
Which one?
What I know...
Are you saying from morning up to now?
What I know, my Lord, is that when you open up a case for evidence to be called, you cannot go to submissions unless all the evidence is tendered. So my question would be, are we adjourning until 17th? Okay. I have had the guidance of the court about issues which are strictly legal, issues which are not strictly legal, but I don't think that there are issues which are strictly legal in this sense, because the process of the constitutional amendment has both issues of fact and of law, and sometimes may be a little bit difficult to separate for both of them, because they are talking about the process of amendment of the Constitution, which began with an action of presenting a bill for substitution and that, and then because of those attended processes, the articles of the Constitution are alleged to have been contravened. So it is a mixed bag.
Do we all know what the specific witnesses whom we have now ruled will have to appear here for cross-examination? Do we know what they state in their affidavits?
I beg your pardon, my lord?
Do we know what these witnesses who are being summoned to appear here for cross-examination, do we know what they stated in their affidavits?
My lord, we of course know what they stated in their affidavits.
If so,
For the plaque,
if so, no, I haven't done with my question. So, have they covered all the issues you've agreed on?
I would say yes. Because, my lord, it is going to be, I don't know, maybe I may be the only one who is at sea here, but that is what
My lord,
I
she's
see.
not alone. I'm sorry, my lord. You see, it's like this.
You tell the guardian what your name is.
Ladisa Surakafuzi. I know, my lord, it seems the court has targeted the time for completing these proceedings. But one thing is very clear. For example, this
Yes, I want to finish before I die.
yes, the Attorney General has continued to serve us affidavits even up until we finished this morning session, which means that I'm not blaming the Attorney General. I think they're on pressure to make sure that they're doing a good job on their side to respond to the petition. Now, that kind of pressure, my lord, even for us, we need time to rejoin. So, my lord, much as we can, we all want to have this thing behind our back, but in a very decent way.
Okay,
So
thank
that
you.
we're very sure-
No, I've understood. We have understood. No, the problem here is, in the very first place, we should be dealing with the issue. We are not yet on submissions. You will be raising this after we have gone through the issues which you agreed on at the scheduling conference. After that, is there anything you want to take away? Is there anything you want to add? And then we agree on the submissions. How are we going to submit? Then we would have raised this.
I don't understand what the land was saying. I didn't get you because we already have evidence. The trial has already gone on. You have evidence on record, both on oath by affidavit. You have replies, and you also have evidence. You also have documentary evidence. I don't understand what the problem is. Because what happens in instances where, for example, additional evidence is called? You try the other issues afresh. What happens in instances where a witness is recalled for further cross-examination? You retry. What happens in instances where both for example, the prosecution and the defense or have closed their cases and the court calls its own witness? Because here we are not having evaluation of evidence on its own and submissions later. What about, since these are consolidated petitions, what about are based on issues? What about issues which are purely on questions of law? They are not there. There are no issues that this. There are no issues on law that you have framed. They are all issues of fact.
My Lord, I'm inclined to agree with Madame Christine Kawa. This is a petition, and in the petition, the submissions are based on a mixture of law and fact. When you call people for cross-examination on the affidavits, you can't gauge what new evidence will be put on record, because cross-examination is intended to bring out further evidence on the affidavits which may need to be responded to in submissions. While I was really anxious to proceed, I am thinking that we shall not do justice to this case, given the fact that now we are going to open up evidence tethering afresh. We risk finding ourselves being repetitious. We risk finding ourselves entering into areas which we are not adequately prepared for. So for the sake of completeness, since in the wisdom of the court, you have ruled that we allow cross-examination, which is evidence, because cross-examination cannot be on issues of law. But as I said earlier, in a petition of this nature, issues of law are intermingled with issues of fact.
Okay, let me ask Attorney General. Let's look at issue 1.
Actually, my lord, just to have issue number 1, 2, 3, 4, 6.
My lord, I don't know.
No, please.
It is for guidance, my lord.
No.
The last time we appeared.
Sit down first. Sit down. Come again?
The last time we appeared in court, we agreed on issues and we said we are going to amend. We agreed on a few, and the court said that we were going to amend the input.
Why don't you let us read the issues that we have? If you said these are no longer the issues, this is just to make a point. We'll deal with that.
No, please sit down. Sit down. Let me make this statement very clear. These matters were scheduled before the Deputy Chief Justice. The conferencing took 2 days. And the various sides came up with issues that framed, proposed for court to frame. I recall very well, and the records are here. I suppose you've been supplied with the record of the 2 days proceedings. The one there was more readable, and they agreed to adopt those issues like exactly what happened in court. I am surprised. If anybody would say such a thing, records would bear me out. That what court came up with, which was supplied to you on Saturday, I suppose everybody got a copy. Stated exactly what happened in court. That
Didn't you get a copy, Christine Cow?
No, my lord, we didn't get, at least I did not receive any.
But Municipal Putana has a copy.
Mr. Wakafu,
I want to explain, my lord, because you gave me the 11 copies.
yes.
On Saturday at 6:06. I went to my chambers.
No, you forgotten to say that when you left me, you said the other counsel and those from the Attorney General were waiting for you.
Yes, my lord.
Yes.
And I immediately went to Attorney General's chambers. I found my friend Amsubut, Jackie. She was just preparing to go to Mbale. I gave her 5 copies of the issues, and I told her these are for the Attorney General. Then I could not reach the others. I sent by border to my friend Babo. Then the others I sent by WhatsApp.
So anyhow, thank you. Order, please, order. Can we have order, please? Can we have order? Can we have order, please? And that's the document court has, which reflects what was agreed on at the conferencing stage. And that's what my Lord was referring to. That, okay, look at issue number 1, 2, 3, 4, and I added. Leave on 5, it talks about violence and parliament. Number 6, talk about conceptualizing, insulting. In case you think that one needs evidence. Number 7, and so on and so forth. Do this need this weight for cross-examination? That's the question of
My Lord, Mr. Rokafus, can I finish this? First of all, I think it's honest for that state attorney, senior state attorney, to say that they don't have the issues. When the Attorney General has the document in his hands next to you, we know that these are draft issues and we need to have them confirmed. But it's a working document that we have in court. For you to stand up and say there are no issues here is not correct. All I wanted to say was, listen, to reply to the Honorable Attorney General's session, that number 1, the issue, and since we have said this is a matter that is important, I would like not just the council, everybody to listen and understand. The first issue is whether sections 2 and 8 of the Act, extending or enlarging of the term or life of Parliament from 5 to 7 years, is inconsistent with or in contravention of articles, and they are enumerated. What affidavit do you require to determine that? 2, if so, whether applying it retrospectively is inconsistent with or in contravention of Articles 1, 2, 3, 4. 3, whether Section 6 and 10 of that Act, extending the current life of local governments from 5 to 7 years, is inconsistent with or in contravention of. What would stop us from, what would stop you from submitting on these issues that are purely of law, and then the issues that deal with the failure of Parliament to whether the actions of Uganda People's Forces or the police in entering Parliament, we deal with them at the later stage. Whether there were consultations, whether those we can deal with them later.
My Lord, is given your guidance, I think now it is prudent that we formulate issues and agree on the issues that are purely technical and don't require evidence, so that we concentrate only on those. That course of action can be undertaken, though in my view it's a bit cumbersome.
But it has been done. 1 to 4.
I'm not quite sure, but
Actually, it goes beyond that.
I am of the view that we can agree on those issues this Honorable Court deems are purely technical and legal, and if it is the wish of the court. Not the Attorney General. I will just ask you, just a moment, I'm just asking. You can stand, you can stand. No, you can stand, it's okay, because it's not a long question. Somewhere there is the issue of the reading of the bill, the second and third reading of the bill was done when some rules of procedure were suspended, and instead of a gap of 2 weeks, it was compressed. And it is one of the issues. Unless, of course, the Attorney General is saying, no, such a thing did not happen. it took 2 weeks, took 3 weeks, or something like that. Unless, of course, in your pleadings, you contested even that. But if your argument is not based on that denial, say, yes, it happened, but it's protected by this, something like this. Why should it wait cross-examining somebody on how truth do point A to point B? What has it got to do with 2 weeks? This is the position we are saying. And there are many others when you go through these issues which you propose to court and which court wants to now frame formally. There are many, not only those, where you really don't, the evidence on record is sufficient. In some of them, you don't deny that you only seek to explain it away. So why would it wait?
My Lord, that's exactly why I said that we now sit and recast the issues and agree on those issues that don't require evidence.
Okay.
And
Honorable Attorney General, we can begin now. And we've got the issue number. Yes, let us save time, please. Issue number one. Issue number one is a matter of law. Issue number two is a matter of law.
On one, issue number one.
Issue number one.
Must it wait for cross-examination?
no, my lords, I am responding. This is not my case. This is
No.
a different case.
Issues are now joined because you're great. They will not suspect.
For me, if you ask me issue number one, I'm neither here nor there. But I can say it's a point of law.
Yes.
It's a point of law. Yes, Mr. Ugalo?
I want to be on record for something.
No, just no. Don't come.
The point of law, my lord.
Yes.
Point of law.
Yes, my lord.
Mr. Mabirizi?
My lord, for me, I was deferring from.
No, is it a point of law or a point of needs evidence?
For
So
me,
that we must wait.
my line is there is already evidence on record in terms of the Hansard, in terms of their own depositions, and we can always proceed. What they are going to come here for cross-examination is to clarify on what they deposit in those affidavits.
No, we have ruled on that. We've already moved one step.
What I'm saying,
What you're saying, not just a moment. What you're saying, we already said, okay, fine. If either side feel uncomfortable with submitting where there are still more witnesses coming to testify on the same, can we extricate those where there is no contest and we begin this and that, so that when you talk, you would have understood. Can we extricate the ones which does not require any more evidence or any evidence at all because it is not contested? We begin with those. Then we will handle the other ones later. That was the question.
yes, now it's more clear, it's clearer. We can deal with those which don't require any more evidence. But we're saying that which are purely points of law, that may be. But those don't
No,
require
that's
any
one
more
of them.
evidence.
The one which is clear, the point of law, does not require any
So that I agree, my lord. We can proceed.
Okay, thank you. So now the question, my lord, and my lord is going to take charge to go through. My lord Remy Kasula will take charge to go through the issues one by one.
In order to save time, it is proposed that while we wait on the other issues, where the witnesses who are going to be cross-examined may throw some light, we can proceed on these issues where everything is already on record. And that is issue number one, issue number two, issue number three, issue number four. Then we go to issue number 10, number 11, and number 12. Those we can begin submissions And the other issues,
My Lord,
maybe issue number 8 also, whether the passage of the Act without observing 14 sitting days of Parliament between the second and the third reading was inconsistent or in contravention of Articles 262, 263, sub-Article 1 of the Constitution. This one, everything.
And they suppose the Attorney General is denying, saying no.
My Lord, I have other issues.
Sorry?
You know, when court is speaking, Mr. Martin, you've been
My
around for
Lord,
so long, you know now.
My Lords, I am comfortable with the issues as framed by the Honorable Justice Sule, and I concede that we could proceed with them.
Okay. Then along the way, we'll find which others fall under in the same category.
I wanted to mention some others.
No. What I've just said, Mr. Mabirizi, I've not closed the door. We have sufficient material to begin the meal. Then if there is more coming from the kitchen, we will...
If I may mention also, just to be added on that list, because I'm looking at 6A, 6B, 6E, 6F.
You see, for us, Mr. Mabirizi, for us, we are just asking the petition. Can you just add those issues that you consider, each one in your own petition?
Yes.
Add the issues that you will see and know that they do not require the evidence that will relate to the cross-examination. For example, it may be an issue of fact and an issue of law. But in your petition, you have not called anyone for cross-examination, and the evidence of record is sufficient to determine that issue. Why don't we proceed with that?
In view of the fact that the Attorney General, who is for the respondent, says they are comfortable, Mr. Mbale, can we?
My Lord, out of the issues read by my Lord, number 10, no, number 12. Number 12 might require, because that is
Whether section 3 and 7 of the Act, gifting the age limit, are inconsistent with or in contravention of Articles 21, sub-Article 3, and Article 21, sub-Article 5 of the Constitution.
Yes, my Lord, why I'm saying so is because there are some articles which were left out of this.
No, that's okay. When we come to that, you can amend. You can include. That's okay. But let us agree on the principle that that one does not require any cross-examination.
No, my Lord, when you amend and put in Article 1, it will bring in the question of consultation. And that is the question of evidence, how it was done, which my learned friends have asked before. So, my Lord, I think that...
Then it will not be framed like this. It will be framed like without consulting the population or without doing what, the issue would not remain as it is.
Yes, yes.
It has to be expanded to bring in the issues of fact.
That is where we're coming
from. If you just add Article 1, it will not have brought in any issues. You have, because the issue is that we must all understand what it is about.
Most obliged,
my Lord, maybe
about this, I noted down with Mr. Ogalo. Mr. Ogalo, how about the other articles apart from?
No, the other ones I'm okay with them.
Mr. Lokwago?
I have a problem with 11.
11. Whether Section 9 of the Act, which seeks to harmonize the 7-year term of Parliament with the presidential term, is inconsistent with and or in contravention of Articles 105, sub-Article 1, and 260, sub-Article 2 of the Constitution.
My Lord, if you look at the evidence of record, the whole affidavit of the Secretary to Cabinet, Mr. Mittal, is all about that, the harmonization. And we have a number of issues to raise on the issue of harmonization. The roadmap, the referendum, what not, so many things there which we intended to raise in cross-examination in relation to the program being rolled out by Cabinet on the question of harmonization. So
really? I thought
that could be so, but it doesn't come out of the issue. Maybe you have to reframe the issue to bring that out. You see, you have to reframe the issue and say, well, you have to bring the issue, the facts in issue. But here you are only bringing the law in issue.
Yes. Section 9 of the Act,
you have put one
whether it contravenes or does not contravene provisions of the Constitution. 5 minutes, you are done. And the other person, 3 minutes, and we go to the next issue.
My Lord.
Yes.
To tell you the truth, of course we have to obey this vote, whatever you decide, we shall abide by it. But for us who drafted these readings, irrespective of how these issues are framed, the way we have prepared to argue our points of law and points of fact is such that we think we need that cross-examination, including all the issues. I know you will take, for example, the first issue, which you say it's purely a question of law. For us, it's not. Because there was, for example, in the issue number 1, the extension 7 years. This one, we are relying on the evidence of the report of Parliament on people who appeared before it and gave views. In this report, they include people...
No. Mr. Rakafuzi,
yes, my Lord.
Legislators.
And that's
take a seat and I help you. Take a seat. Issue number 1, which both sides proposed for court to frame and court is adopted. It did not come from court, it came from you and from the process. Is not whether the process of enacting that act number something contravene the Constitution. If with the process, you need evidence. This says there is already sections 2 and 8 of this amending act. So the question is whether section 2 and 8, howsoever it was reached at, how it was reached at is not important. It is already law. So we are supposed to determine whether the law as it stands, section 2 and 8 of this act, which amended the Constitution, contravenes those provisions of the Constitution. As simple as that. Not how it was arrived at.
Or if you want to know how it was arrived at, make it an issue. The process leading to the enactment of this and the process leading to this contravened this. Make the process an issue.
I think one of the issues is about process.
Councillor Kapuz, is what you are raising not exactly what issue number 6 is about? Whether the entire process of conceptualizing, consulting, debating, and enacting the act was inconsistent with and or in contravention of the Constitution.
My Lord, 6 has 6 sub-issues.
But those are
So in other words, but we are attacking the process only in relation to those 6 sub-issues.
Let them be 7 and 8 and 9.
So fine. Now, this is how we are going to proceed. The court's position is these issues are going to be adopted in parts, especially the ones which deal with matters of law, the ones which do not require any additional evidence will be handled. And to begin the process, The rest we can determine later. Issue number 1, issue number 2, issue number 3, issue number 4 will be submitted on. Mr. Mbale, can I know from you how you've arranged as counsel for the petitioners to deal with these issues? We are going to begin with the first 4 issues.
My Lord, the earlier Lord indicated that we needed to amend and add one issue. So before we go to the arrangement now.
No, we'll come to that. We're just dealing, unless you amend any of the first 4. If it is outside that, I'm not closing the door. When we come there, we'll allow it. We're dealing with the first 4 because we're going round like the merry-go-round.
My Lord, Aganzi Lester, I am counsel for the petition number 13. With regard to issues number 1 and 3, I have some additions to make.
What do you want to add in number 1?
You want to amend or you want to add another separate issue?
Not a separate issue, but to amend and include other provisions, other articles of the Constitution that, according to the petitioner, were contravened.
In number 1, which one?
Number 1, would like to include Article 61, 2 and 3. Article 261. 261. 260, sub-article 1. Then Article 105, sub-article 1. And lastly, Article 289 of the Constitution.
After 260, clause 1.
1051, clause 1. 105, clause 1. Then Article 289. My Lord, with Article 3, issue number 3, my Lord. Pardon. We would also like to include Article 181, clause 4.
It's there.
It's there.
Yes.
My Lord, unfortunately, I'm having to refer to the one that was on WhatsApp, so I did not have the benefit of looking at the hard copy.
181
was too small, eh?
Yeah.
181, clause 4 is there, and then 259, clause 2, paragraph A.
61.
My Lord, much obliged, it's included.
Does it cater for everything?
Yeah, it caters.
So it is only on issue number 1?
Yes. My Lord, the last one is issue number 12.
No, today let us handle
Only the
first 4.
Much
As I said, when we go later on, we will now.
obliged.
But council, suppose you just say it contravened Article X. Would court preclude you from, in the course of your submissions, to say in addition Article ABC in view of the fact that we are dealing with the Constitution as a whole? Would it stop? Can anyone object that since it's not included in the issues, you can't add?
My Lord, I am also, I just wanted just to make
Because it is law, that is law really.
Yes.
And with the law you can cite anything.
Yes.
But it appears that it's just an issue of wasting time, make sure the petition is not hard or something.
My Lord, we are just trying to be specific with the articles that we believe were contravened.
It's better to be specific in your submissions than just...
Okay, what we will do now is this,
Yes.
as a middle ground. Point out in all these issues, if there are provisions of the law which you would have wanted to cite, but you somehow you failed to cite, communicate to us on the other side, communicate to court, to take it in and proceed.
But the additional issue I wanted to include here is very small, very simple.
Proceed.
This one could be allowed. My Lord,
And the transcribers are complaining that they don't get the names of all.
Well, Lukagerius, once again. My Lord, it stems from the argument on page 8, page 8 of our petition number 5.
paragraph.
What is the issue? What is the
issue?
What is the issue?
The issue should be captured under paragraph 6 on the list of issues as a sub-issue. So we
under issue number 6.
Under issue number 6, EFG.
So what is the issue?
F then G. Yes. Here it's whether the Constitutional Amendment Act 2017 was against the spirit and structure of the 1995 Constitution. The spirit.
Where is this? Which section is the spirit? Which article?
The article, the structure, the spirit and the structure, we intended to extensively submit on this.
Where is the spirit?
The spirit, my lord, it's covered in paragraph 12. It's brought out in the national objectives and directive principles of state policy.
Yeah, I think so.
And the preamble. So it's brought out.
At least that's better.
Yeah.
You know where to
Most obliged, my lord. We clearly pleaded it in paragraph 12.
Attorney General, what do you say?
My Lord, I don't object, though I want to put in the record that such an issue is frivolous, because nothing precludes him from making a submission to that effect. So,
since he wants to get out of objection, why can't let him have it?
So
my lord, if I can.
Please. Paragraph G of issue number 6 is whether the Constitutional Amendment Act of 2017 is against the spirit and the structure of the 1995 Constitution. Is that okay?
Yes, my lord.
Can I hear from Mr. Mbale, please, both of you sit down. My lord, what you requested for, I've granted. No, I
My lord, we did have the meeting cancelled for the petitioners, and we adopted the guidance given by my lord that one council will submit from the point of view of his petition, then the other councils will also submit, that will avoid repeating what has been covered by earlier council.
Meaning, if for example you pick on issue number 1,
yes, madam,
you submit on the issue number 1 and you refer to all the evidence across.
Yes,
is that the position? So that when Mr. Lupago stands up, he's not going to submit on number 1 again?
No, my lord. Because we found, when we discussed it, we found that maybe you will find, for example, in my issue, I have left out an article which Mr. Lupago has pleaded.
Okay.
So I cannot really argue it effectively, because I didn't really maybe believe in that article.
So how have you planned to avoid Mr. Lupago standing up to speak for 2 hours, repeating what you've said, using different words?
My lord, I have great confidence in all council here, that since they'll be here and
because we do not intend to be rude. We thought you would take care of that. Where you submitted, and Mr. Lupago says, my learned friends are submitted on articles 1, 2, 3, 4. Mine is strictly on Article 5 only. On Article 5, it is this. Is this what you mean?
Yes, that's right. My lord, I take it that reference to Lupago means to all of us.
It's because you've been so prominent today, so your name comes more easily. Tomorrow it might be another person. Yes, Mr. Mbale.
My lord, we agreed on that. Only that maybe it needs to be clear that we agreed that after someone has submitted, then every person must be able to present what he knows as his evidence, and maybe to add on an authority or his view, but without repeating the other side.
Okay, fine.
Secondly, my lord, the other time at conferencing, there was an issue which was not agreed upon, and which I notified you that I would.
Okay, can you raise it now?
Call
the one where the single judge disagreed with you. Can you raise it now?
Yes, my lord. My lord, at the beginning, I had framed an issue, my lord, that whether the president elected in 2016 is liable to vacate office on attainment of the age of 75 and fresh elections held. Whether the president elected in 2016 is liable to vacate office on attainment of the age of 75 and fresh elections held. My lord, this was pleaded under paragraph 1.1 my petition, 2.1n the same petition, and
does the Constitution provide for if the president leaves office?
My lord, my view is this. Since I pleaded this, and I am reading where it's pleaded, you hear it, then you terminate either way.
Oh, okay.
Yes, you hear the issue, then you terminate either way.
Yes, but my problem is that this is not a constitutional issue, the way you have framed it. Whether a presidential election, a president elected in 2008 is liable, where is the constitutional issue? Where is the constitutional?
In accordance with which law?
You must
say
in compliance.
Mr. Mbale, you should say whether the continuance in office of the president contravenes ABCD of the Constitution. We haven't seen anything that is for constitutional interpretation in the issue as it is framed. So you must rephrase it in such a way that it begs a question for constitutional interpretation. The way it is phrased now, it does not beg a question for constitutional. So you have to refer to the Constitution or something like that. It has to beg for constitutional interpretation.
Okay, I now rephrase.
My Lord, Mr. Mbale must rephrase also in line with his pleadings, because the last time we checked his paragraphs, they were from 31 to about 36. They did not show anything on contravention of the Constitution. They were plainly worded the way he has framed this issue. So maybe you can point to where he's drawing from his pleadings and whether that is an issue that can be determined by this court.
Do you need some time, Mr. Mbale, so that
No, my lord, I'm ready. I have my pleadings here, and I have the articles with me.
Yes, so tell us.
I point out my pleadings.
Okay. We will help you. If the sitting president continues in office beyond the age of 75, you want us to determine whether, yes, in the light of which provision of the Constitution?
So, I was reframing.
No, just tell us the provision of the Constitution. You cannot reframe the Constitution, no.
The issue. My lord, Article 83, 1B.
No, start afresh so that we can rephrase, so that the transcribers is on record. Your rephrase is on record. In respect of what Council Power has said, I think you should, Council Power, you should not, the alternative, you should not bother about that very much, because if we find in our determination that this was not backed up by the pleadings, we will make a finding on that. But as of now, we frame that as
your point of view of submissions, that is not clear.
That can come in reply that that issue is not supported by the pleadings, and we move forward.
Yes, Mr. Mbale, which articles? Article.
I'm now rephrasing that whether the continuance of a president in office after attaining the age of 75 years is inconsistent with and/or in contravention of Articles 83 1B and 102C of the Constitution. 2C 102C as it was.
The first one is 83 1B.
83 1B.
Then
2C as it was.
How can we interpret a provision of the Constitution that is no longer in the Constitution?
But it is still, it is under challenge. The amendment is under challenge here.
But until the challenge has been upheld and it comes back to the Constitution, how can we interpret a provision which has been, which is no longer part of the Constitution?
Because unless they're saying the sitting president clocked 75 at the time when 102 was still as in fact.
Because he was appointed under that old law.
No. If he's going to clock the 75 years today or tomorrow, then it's going to be under new an amended constitution. That's what my Lord is asking. How do we now use the other one? Fine. It is your case. So,
yes, in my arguments I shall show.
No, fine. Any other matter? Any other provision of the Constitution? Those are the two.
My Lord, I'm looking at those two.
Thank you. Learned Attorney General.
The problem I have, my lords, is that even when you draw an affidavit to support your application, the amendments in the affidavit must emanate from your pleadings.
Of course.
I am scanning Mr. Mbale's pleadings, and some of these things he is listing as issues don't appear anywhere, because an affidavit is only evidence to support the application as we put it. So if we allow him to do that, it would be introducing a totally different case from what he came to court with.
Isn't it in his pleading, even before his application?
My Lord, I say it when you look at paragraph 1.1 of my petition. If I may read it. It says, the petitioner alleges that the action of the respondent and his agents to claim that the term of office of the current president expires in the year 2021 after expiration of 70 years is inconsistent with and in contravention of Articles 102B and 102C of the Constitution as they were in the year 2016 when the current president was elected into office, which peg the qualification of the president to those of a member of parliament, and hence when he or she ceases to possess the qualification being below 75 years, such president ceases to be eligible to be so, and new elections must be conducted. That's my plea.
Whether we agree with him or not, it is in his pleading. It's not so learned at all.
Okay, we shall get time to...
Fine.
My Lord, I wanted to amend, to add something to issue number 9. Issue number 9, it now reads, whether the presidential assent to the bill allegedly in absence of a certificate of compliance. I want to add the word valid before the word certificate.
Sorry?
So that will read that whether the presidential...
valid,
yes.
valid certificate of compliance.
Yes, my Lord. Because right now the validity is in issue after the discovery. That's all, my Lord. Thank you.
But Mr. Mbale, we understand, at least I understand that the issues we have. That what we have termed as issue number 13 now, because we have that the issue raised about the presidential term expired is not part of the agreed issues in the consolidated petition.
Yes, my
but
lord.
it is your issue as in your petition, and you will argue it.
Yes, my lord.
Alone, but it's one of the issues that we are going to argue, but not the consolidated one.
Yes, my lord. But you also discover when we are meeting as the petitioners, there are also some issues which result for some of us, which were not in each and every person's plate. So among ourselves, we know who you are.
Fine, please, Mr. Mbale, I set the ball rolling.
Yes, my lord.
Would we be asking you to bend too much? If you say, begin with the first 4 issues as friends.
No, my lord.
Would you like to begin?
Yes, my lord. My lord.
Before you begin, on issue number 1, what time do you propose to take? Issue number 1.
My lord, I intend to argue issue number 1 and number 2 together.
Okay.
But the authorities in respect of number 3 and 4 are the same as those in number 1 and 2. So I may have to spend more time on 1 and 2, but when I come to 3 and 4, because I already have referred to the authorities, I will spend very little time on 3 and 4.
So when you say more time, 10 minutes?
No, my lord.
How much time? That's what I was asking.
My lord, on 1 and 2, I would ask maybe for 20 minutes.
20 minutes.
Yes, my lord.
Grant.
Obliged, my lord. My lord, before I embark on addressing you on these issues, I invite your lordships to apply the principles of constitutional interpretation, which were restated in Constitutional Petition number 16 of 2013, Saleh Kamba and others versus Attorney General. These are to be found. The authority is the list on a list is number 1 in the petitioner's list of authorities. At the pages 11 to 14. Briefly, my lords, they are 1, that the Constitution is the supreme law of the land and forms the standard upon which all other laws are judged. 2, both the purpose and effect of legislation are taken into account in determining constitutionality of that legislation. Number 3, that the entire Constitution has to be read together as an integral whole, with no particular provision destroying the other, but each sustaining the other. Number 4, that constitutional provisions containing fundamental human rights should be given a dynamic, progressive, liberal, and flexible interpretation, keeping in view the ideals of the people, social and political values, so as to extend the benefit of the same to the maximum possible. Number 5, that where the words and phrases are clear, they are given their primary, plain, ordinary, and natural meaning. Number 6, where the language of the Constitution or statute so to be interpreted is imprecise or ambiguous, a liberal, generous, or purposeful interpretation should be given. Number 7, the history of the country and legislative history of the Constitution is also relevant. And lastly, that the national objectives and directive principles of state policy are a guide in interpretation. My Lord, those are the principles which were stated, and I invite your lordships to apply them in the instant petition. And my Lord, I also wish to emphasize the remarks of Remy Kasule J.A., which are to be found at page 3 and 4 of the authority to be found at 2. It's also found at 1. It's a follow-up on that one, the same authority. My Lord, the emphasis is here is because of the constitutional and political instability which has plagued this country since independence. And that therefore, in interpreting the Constitution, that history of the instability should be taken into account, and the Constitution should be interpreted in such a way as to promote democratic values and practices, while at the same time doing away with those aspects of governance which are likely to return us to the past. My Lord, as pointed out by the judge, the 1995 Constitution was a result of struggles by the people of Uganda against oppression and tyranny. And so, my Lord, it is important to that is political and constitutional instability. So we should give the interpretations which are progressive, which give effect to democracy, to democratic practices. My Lord, having started with that, now I want to refer to it to begin arguing issue 1 and 2.
I'll begin timing you. You have 20 minutes.
We begin now. Okay. My Lord, Section 2 increases the term of Parliament from 5 to 7 years. And I submit that this is inconsistent with Article 8A of the Constitution. This article imports the directive principles of state policy and makes them part of the Constitution. My Lords, Authority 3, Constitutional Appeal, number 1 of 2015, at the pages 37, 40, and 41. The Supreme Court, in interpreting the Constitution, imported the democratic principles enshrined in the directive policy and used them in the interpretation. It is stated that one of the principles of democracy is separation of powers, and that in the interpretation of the Constitution, it would take into account that doctrine of separation of powers, because it is a principle of democracy. My Lord, in the present petition, I submit that the principle applicable is that one of the rule of law. That the principle of rule of law should guide your lordships in interpreting this section, to hold whether it is constitutional or not. My Lord, the essence of rule of law is simply that all of us must obey the law. Whether we are powerful, whether we are not powerful, we must obey the law which has been set for for ourselves. I propose to show my lords that in enacting and increasing the term from 5 to 7, Parliament did not follow the law. It went against the rule of law. And therefore I invite your lordships to use that principle to hold that the enlargement was unconstitutional. My lords, Article 94 of the Constitution.
If I can seek just small clarification, I have not looked at. Does the enlargement allow for the earlier terms that the election for 5 years will expire and then immediately this one begins without an election, or is it a continuation?
No, I'm talking now about the Constitution, the general one.
It's a continuation.
Yes, the general one.
The enactment of the continuation from 2016 up to 7 years expire.
To 2023 and from there on to continue with 7 years. My Lord, Article 93 of the Constitution gives power to Parliament to make its rules of procedure. The power to make rules of procedure of Parliament emanate from the Constitution itself. They are not, therefore, to be equated to something like a statutory instruments or regulations. They are above that because they emanate from the Constitution. And my Lord, I would wish to refer your Lordships to Authority 2 on the petitioner's list of authorities, BT and another versus the Minister of Justice and the Legal and Parliamentary Affairs. My Lord, it is a Zimbabwe case, but it has persuasive authority to your Lordships. And my Lord, I refer to your Lordships.
The Beat is brought to you by
It's the feeling.
The beat.